one we're going to deal with this morning is the reinstatement of the third-degree murder charge. And so who would like to speak to that issue first?
Good morning, Your Honor. Mr. Katyal will be addressing the court on that matter.
All right, let me give my understanding where we're at. I had denied the motion to reinstate, saying that the Noor case was not precedential at that time, and that was the sole reason for the denial of the motion. That was appealed to the Court of Appeals, which said no, it had immediate precedential value. Judgment had not been entered yet. Petition for review is taken by the defendant. The Supreme Court has denied review, remanded it back to the Court of Appeals, who then entered judgment. So, judgment has been entered on the appeal in this case, so I think we can address the merits. So, Mr. Katyal, if you would.
Thank you, Judge Cahill. May it please the court, we really appreciate the opportunity to be here. And you've already said in your last order, you said, quote, if Noor is precedential, this court would now be duty-bound to follow it and grant the state's motion to reinstate murder in the third-degree charge. And that's what we're asking for at this point. Mr. Nelson made two arguments before you to argue against that. One was that Noor wasn't precedential, and the second was that there were some differences in the facts. Any other arguments about prejudice we think are well forfeited at this point. Our initial motion to amend the complaint had pages 8 to 10 were all about how there wouldn't be any prejudice, and Mr. Nelson chose not to contest any of that. So really, I think it's a very straightforward decision. State versus Bloom and other cases from the Minnesota Supreme Court say that this court is relatively free to permit amendments to charge additional offenses until jeopardy is attached, until the jury is sworn. And, that's obviously not happened here. And so we think you have the absolute discretion to have this charge, and we think you should. It reflects the gravity of the offenses.
I do believe the Court of Appeals did, however, remand it for the defense to bring on any other grounds they think I could use to deny it. So, Mr. Nelson, I'm going to actually ask that you be at the lectern.
Your Honor, is there, I don't know, is there a way I can turn this monitor off or something? Because this is all very distracting, and I'm sorry.
I think you can just turn it down a bit.
This one?
Don't close it, but...
That okay?
Does that work?
Okay. Yes, Your Honor, I believe that there are three bases under which the court could deny the state's motion. First and foremost, what I would note is that this case is both procedurally and factually different. Ultimately, what the Court of Appeals said in the opinion for this case, in Chauvin, is that if it's precedential, it has to be applied consistently to procedurally and factually similar cases. So there's a question of the distinguishment between Noor and that line of cases and the facts of this particular case. That's one ground, and I can address that in a second. The second is that I'm raising the question, and we raised it in our response at the Court of Appeals, of the ex post facto application of Noor. Third, Your Honor, under Baxter, this court just has the housekeeping ability to deny. So, addressing the first issue first, we have to remember that Noor, what Chauvin says is that Noor is precedential, but there is still the Fabio versus Bellamo case, which says that once the Supreme Court grants review of a case, it limits the precedential value. Fabio versus Bellamo says once the Supreme Court has granted the petition for further review, that case is of minimal precedential value. So you have that to start with. So the question is this case factually or procedurally different than the Noor case? And they're completely different. What we've seen in these lines of third-degree murder cases is really two lines that have come. You've got the Noor, the Middich, and the Hall cases, which are all cases that look at whether there was sufficiency of the evidence from a post-conviction standpoint. That's one line of cases. You have a second line of cases, the Zumberge, Lineweber, Hansen, that whole line of cases that look at and analyze whether third degree is appropriate as a lesser included, right? And so you have these two lines of cases. Ultimately, looking at the Knorr line of cases, where there's a conviction, it's a much different standard than the appeal or than the lesser included standard.
But Mr. Nelson, aren't I pretty much restricted? The Court of Appeals specifically remanded to this court with instructions that I make a decision consistent with their opinion.
Say in the Chauvin decision that you are bound to, or you are permitted to review other issues, right? And the question is, and what Chauvin says is, if it's precedential, right? It's precedential. That question has been answered at this point. Is it factually or procedurally similar?
Okay.
Right?
Go ahead.
And so under Knorr, if you look at the facts of Knorr, it's a Minneapolis police officer. This is a case involving a former Minneapolis police officer. And that's about where the similarities end. And if you look at the line of cases, Knorr, Middich, Hall, all three of those cases, there's some sort of an instrumentality that is used, a gun or a car, generally speaking. Those items could be viewed as inherently dangerous. So in Knorr, right, they're saying what I understand Knorr to stand for is the single person rule, and whether a single person can be the focus of the third degree murder. But in the Knorr case, Mr. Knorr shot his gun across his partner's chest towards a silhouette that could have been anyone or anything. They just saw this biker. Anybody within the line of travel of that bullet was put at risk. It happened to be a single person that was there. And I think that that's significantly different factually from what is alleged in this particular case. They are alleging that my client did not do something inherently dangerous. It was focused on a single person. So factually, these cases are considerably different. Ultimately, they're very different procedurally as well. Because again, Knorr, Middich, Hall, those were all post-conviction appeals to look at the sufficiency of the evidence. Procedurally, we are pre-trial. This is a motion to amend the complaint. And it's similar, it's a similar standard, the abuse of discretion standard for this court, to determine whether a lesser included should be added, right? So we're procedurally more consistent in the Zumberge line of cases, right? So that's number one. Then we have the ex post facto. Sorry.
I think they are different, nor in this case. I said so in the original probable cause order. Said we could understand how Knorr falls under third degree murder because firing a gun out the window endangered not just the person who was killed, but also that officer's partner, biker who was going past at the same time. And so that was clearly fit in the universe of depraved mind, danger to others, plural.
Right.
And I think the distinction we made in the original probable cause order last fall was this is a different case. It is more focused on a single person. And clearly I said the single person rule applies or doesn't apply depending on how you state the rule. And basically there has to be more than one person endangered by the conduct. The Court of Appeals in Knorr said they did not take the route of saying we don't have to reach the single person rule because it did endanger others, not just the victim who was shot. They didn't take that route. I think they didn't have to, but they didn't. They said single person rule. When the animus is directed at a single person, that's enough. It falls within the gambit of a third degree murder charge. So I agree they are different cases, but it seems if anything, this is more the single person rule application, even more than Knorr, and I'm not sure why they felt the need to decide it that way, but I'm not questioning the Court of Appeals
Well, I mean,
This time.
and that ultimately what the Court of Appeals reversed on in this particular case was a very narrow inquiry, which was simply the question of the precedential nature of their opinion and whether you were duty bound to follow it. But again, you are still able to analyze the case from the facts, right? Because that's what the Chauvin case says. The Chauvin case, the Chauvin Court of Appeals decision specifically says that you're duty bound to apply precedent provided it is a factually similar case, right? And that's, so inherent in that is your discretion to say, this is not a factually similar case. This is a distinguishable case. Whether you apply the one person or the single person rule, it's immaterial, is factually significantly different. And so that wouldn't apply. But if you go back over then and look at that other line of cases, the Zumberge line of cases, and you look at what are the differences between these two types of lines of cases. Well, again, in Knorr, it was a gun. It's inherently dangerous. In Middich, it was a gun. In Hall, it was a car being driven recklessly into some person or into any random other car. In all of the other cases, it's really much more of a focus on, it was obviously the defendants seeking a lesser included, but they distinguish, they're able to factually distinguish. Even though there was a gun, you pull up a gun and you shoot it at a crowd. They're all instrumentalities. Factually, there is no instrumentality here other than arguably Mr. Chauvin's knee, which is not inherently dangerous, right? So that's, I think, the main factual